Andrew Childers appearing on behalf of the people.
David Goldstein appearing on behalf of the defendant.
What you're about to witness isn't just a routine courtroom appearance. It's a layered legal chess match involving alleged home invasions, missing firearms, tangled relationships, and a judge forced to decide who can be trusted to walk free and who poses a real danger to the public. This case opens with a request that sounds simple on the surface, a defense attorney asking for one small change in bond conditions. But behind that request is a web of accusations involving armed robbery, unlawful imprisonment, and a coordinated plan between multiple defendants, including a husband and wife. That's where this gets unusual. Normally, a no-contact order is standard in serious criminal cases. It keeps co-defendants from aligning stories, tampering with evidence, or influencing witnesses. But here, one of the co-defendants is the defendant's own wife. They run a business together. She manages his medical care. And now, legally, he's forbidden from even speaking to her. So the defense frames this as a practical issue, a humanitarian one. But the prosecution frames it as something else entirely, a safety issue in a case involving chainsaws, firearms, and a home invasion. Judge Simpson is about to weigh convenience against risk.
Your name, sir?
Myron Couch. Your Honor, this is a co-defendant to Mr. Bernstein's case a few minutes ago.
June 12th.
June 12th, yes, Your Honor.
Probable cause conference, June 12th, 2025, 9 a.m. Bond continued.
There is one thing I'd like to address as far as the bond is concerned, Your Honor, and this is a very unusual situation. Mr. Couch, when he was arraigned by the magistrate said the standard conditions, among them being no contact with co-defendants. One of the co-defendants in this case is my client's wife, which creates several problems. One of which is that they run a business together, which they can't do if they can't have any communication. The other is that Mr. Couch has some significant medical problems. She is usually his advocate, takes him to doctor's appointments and so forth. So we're asking if the court would consider dropping that provision. I know she's going to have to address it when she's before the court next week. But as far as my client is concerned, we're asking if the court would drop the no contact provision, specifically as to his wife, not the other defendants.
I would ask that no contact order. This is a pretty significant case involving breaking into a home, tying up individuals, using a chainsaw to access portions of the house looking for money. There was the possible use of firearms. The defendants are all charged with armed robbery, unlawful imprisonment, so on and so forth. It does appear, based on the investigation by the state police, obviously a plan and concerted effort by these individuals. I would ask, I know it is unusual to have husband and wife charged as co-defendants, but I would ask that no contact will remain in effect, at least.
Very briefly, Your Honor, the arguments that Mr. Childers made really go more to the issue of what the bond should be in terms of dangerousness, et cetera. The magistrate considered those.
They were acting in conspiracy with each other, doing it. You would want to keep those people separated.
I wouldn't, Your Honor, but the court might. I appreciate that.
I'm saying you in the general sense of those that rationally think it through. I'm going to deny the bond request. I'm going to have his bond continued till I.
That denial isn't emotional, it's surgical. Judge Simpson doesn't lecture, he doesn't dramatize, he simply declines, and in doing so, signals something important. This court is not prepared to relax conditions until it understands the full scope of the connected cases. That's judicial caution in its purest form. He's effectively saying, I won't make a partial decision in a multi-defendant case. And that's critical, because bond conditions aren't just about this defendant. They ripple outward. Change one and pressure builds to change the others. The judge pauses the entire issue until he can see the full board. And notice what's missing. There's no sympathy-driven carve-out. No exception for marriage. No provisional window. The message is clear. This case is too serious for shortcuts. That tells you how the court is reading the file. Chainsaw, firearms, tied victims, coordinated entry.
Maybe take a look at the other case that I don't have before me that's set for next week.
Yeah, she's set for next week. I'm assuming hers will get kicked over to the 12th also.
12, correct. Who is her counsel?
Hers?
Yes.
I don't know, Your Honor. It's not public defender because they have another person that's up today. Is the other one up today?
Yes. It's not the public defender's office. I don't know whether she retained her own attorney or.
What's her name?
Christy.
Last name, Couch.
Couch. Christy.
I know she
How
was.
do you spell Christy?
Kristi. I know she was going to talk to Jeff Osmond in Monroe, but I don't know if she's actually ever done that or not. I spoke to him briefly last week, and he said he might be representing her. But
okay, so she's been arraigned.
She's been arraigned. She was arraigned the same day as Myron was, Your Honor.
She was arraigned. My understanding is the judge or the magistrate gave her a PR or a substantially lower bond, and for that reason gave her more time. I think at the request of the PD at the time of arraignment, set a later PCC.
Right, but she would have been given counsel.
Your Honor, I was present at the arraignment. She indicated she was going to. I indicated for her because she had asked me to stand in at the arraignment. We indicated she was going to be hiring, and as I said, she mentioned a Jeff Osmond. I spoke to Mr. Osmond. He is familiar with the situation. I can contact him, make sure if he's going to represent her, he gets an appearance in before next.
Well, if he gets an appearance in and just a stip to adjourn, so they don't have to.
Okay, I can.
That's what I was trying to get at.
So. Okay, I can let him know that, Your Honor.
All right. Okay, thank you.
Thank you.
On behalf of Ms. Gales, who stands by my side. Ms. Gales, can you please state your name again for the record?
Carla Shendale.
All right. Ms. Hughes, I don't know how much of what we went through you want to place on the record.
I appreciate you giving me the opportunity. What I would like to place on the record is that at the time that I charged this, I requested $250,000 after any other moving that request today for the reasons that I mentioned at the time. If at any point she is released from custody, I am requesting a home confinement tether. Thank you.
All right. Thank you.
This is where bond law becomes human. The defense is no longer arguing theory. It's arguing reality. Children, dependents, a parent who holds a family together. That's deliberate. Courts are not blind to consequences. They know pretrial detention punishes before guilt is proven. But notice what's happening beneath the surface. The defense isn't denying the allegations. It's conceding risk and asking the court to manage it instead of containing it. Home confinement is the middle ground. It says we accept supervision, but we reject incarceration. Yet Judge Simpson is operating on a different axis. He's asking a more fundamental question. Where is home? Every alternative bond structure depends on one stable truth: location. A tether only works if there is a fixed, lawful place to tether someone to. And this defendant's life is built on address instability.
Your Honor, I would just add that I would just ask for a reduce. I don't know that $250,000 is necessary in this case. My client is willing and capable of doing home confinement. Now, home is in contest, as I've been made aware by the court. However, it is my understanding that mom has a place to go. Mom has a place that she can stay. I don't currently know where that address is at. Mom had to leave to go pick up my client's daughter from school. She does have a 20-year-old and a 17-year-old whom she resides with, whom she takes care of. Her son helps her with regard to the finances. Her daughter, like as I said, is 17, still in high school. I just would like an opportunity for my client to be able to get out. I don't know that $250,000 is necessary, although I do understand the court's concern when it comes to there being a weapon in question out in the sphere.
All right. Well, and again, I don't want to reiterate everything that we went through, but the sum and substance so that there's at least a record of the court's decision regarding bond in this case. This case involves allegedly the entry by this defendant into someone else's home. Critical to that is the changing of the locks on that home that belonged to somebody else. I am also to understand that she was in possession of a deed to that home a license which indicated that address, and voter registration at that address. As it turns out, at least the investigation has revealed that address is not hers. It belongs to two other individuals.
Those are the allegations, yes.
Right. That would have occurred basically December 25th through the 30th, but somewhere around that area. The court was then informed that there was another address on Panama that the defendant, that was her address. Going through the court records, because that's this court's jurisdiction for summary proceedings or landlord-tenant, a judgment evicting this defendant was issued by myself in mid-December, approximately that same time that she allegedly entered these other individuals' home and sort of set up domicile there. So that's curious enough. Trying to figure out under what terms and what conditions the court would feel comfortable releasing the defendant, because these allegations are rather serious, that because these folks' home, these allegations, was transformed. There is approximately, these allegations, about $11,000 plus of property missing from these premises while these people were on vacation or just had left their home for a moment. There's also a weapon that is missing. The defendant is there and doesn't seem to be able, or doesn't seem to, under color of any right, have any ability to be in those premises.
This is one of the most dangerous patterns a court can see: repetition. Judge Simpson isn't reacting to one incident. He's identifying a behavioral loop: eviction, relocation, occupation, conflict, removal, repeat. From the court's perspective, this isn't chaos, it's trajectory. And trajectory matters more than sympathy. What makes this especially severe is the timing. The alleged entry into the Ann Arbor home occurs immediately after eviction elsewhere. That transforms this from a misunderstanding into a survival strategy. Then comes the missing firearm. That changes everything. A missing gun in a bond hearing is not just evidence, it's threat potential. It's an unknown variable that the court cannot model, and courts do not gamble with unknown weapons. So now the judge is balancing unstable housing, repeated boundary violations, missing property, a missing firearm, a return after police instruction. That's not a defendant asking for trust.
So there is this other address, Roundtree Boulevard in Ypsilanti Township, which is the address which is in the court file, which the court could see fit to potentially tether. Initially thought that I could tether this individual to that address, that there's something that we could do with that address to keep the public safe. I'm then informed, so that, again, the record's clear, that on March 11th of this year, that the defendant, although contacting the police, returned to the address in Ann Arbor, which was the address where she had moved into again. When the police and everybody had told her to stay away from that address, she went back there. That's March 11th. That the dates are important. And I informed counsel that I then went back to look at, or just the curiosity for the court standpoint, as to why she was returning to that address if she had this other address in Roundtree Boulevard, Ypsilanti Township. Turns out when we look up the court cases in the 14B jurisdiction where Roundtree would be, that she is indeed being evicted from that Roundtree premises, which fits factually into what she had previously done. When there's an eviction, she goes to this other house. there's now this other eviction, she's showing back up. So I don't know where this defendant would go. I don't know where she is even supposed to be.
This single sentence is the spine of the ruling. Courts don't release people into uncertainty. A tether is not freedom. It's a contract between a person and a place. And here, the court has no legally reliable place to attach that contract. Every address this defendant provides collapses under scrutiny. One is not hers. One is under eviction. One is contradicted by licensing records. So the judge isn't saying she shouldn't be released. He's saying the system has nowhere to release her to. That's an administrative dead end. And when the system hits a dead end, it does what it's designed to do. Pause movement. That's why this isn't framed as punishment. It's framed as incapacity. I can't release someone if I don't know where they belong. It sounds cold, but from the court's standpoint, releasing a person with no lawful destination is negligence. This is the quiet power of procedural reality. It overrules empathy without ever naming it.
Counsel did inform me upon the court's question that the Roundtree address she had been residing at for approximately 5 years. That fits with various court records that that's her address. But her current driver's license is for the Panama Street address. Moreover, the Panama address, the license was issued to her after she had been evicted from those premises. So I'm not clear what's going on. That means she would have had to present herself to the Secretary of State for the issuance of that driver's license, knowing that she no longer resides at that address. And she's at another address. And then there's this other address on Roundtree. So again, I don't know, even if I'm disinclined to, at this point, give a tether because I don't know where she is supposed to be.
I understand, Your Honor. Thank you, Your Honor. I did want to inform the court as well, Your Honor, aside from bond, that I've talked to my client, I've talked to my client's mother, I've talked to prosecution, we'll be submitting an evaluation for competency to this court as soon as possible. I can have that done and submitted by tomorrow so that we can start the proceedings on that. And I can always file a motion as I know to do if I find out a place for her to go. Should this court, it doesn't sound like this court is going to do anything but remand her at this point. I understand the court's position on that. I would again just renew my request for something a little more palatable than $250,000. I don't know that is necessary in this case, although I do understand the court's concerns as I stated.
Maybe I wouldn't consider the people's request in terms of its monetary amount necessary if I didn't have the incident from March 11th.
Okay.
I have very serious concern. And well, the incident from March 11th, where she goes back to the premises, the missing firearm, all of those things are of grave concern to the court and I believe pose a danger to the public. So I am going to set the defendant's bond in an amount of $250,000.
This is the pivot from uncertainty to restriction. The judge ties the bond not to the offense alone, but to flight risk. And notice how that risk is constructed. Ties to other states, a visiting out-of-state parent, no stable address, prior disregard for boundaries. Flight risk isn't about intention. It's about capacity. If a person can vanish easily, the court must assume they might. So $250,000 is not symbolic. It's a barrier calibrated to reality. It ensures only a defendant with extreme backing, structure, and oversight can leave custody. And the GPS tether condition seals it. Even if money appears, movement does not. This isn't pay and walk. This is prove you can exist under control. Bond becomes architecture.
Cash surety. I would, part of the other, The other concern, counsel, that I have is that the defendant has ties, as I see them, to other states. I see that she has ties to Virginia and Tennessee. And my understanding is that her mother is up here visiting.
Yes, Your Honor.
From what state?
Virginia, Your Honor.
The other condition is, at least at this point, is GPS tether, home confinement prior to release. So if she were able to post this, she'd have to be on a GPS tether for home confinement. Our difficulty at this point is I don't know where that is.
Okay.
All right.
Thank you, Your Honor.
Thank you. 2 minutes. Thank you.
Okay.
Yes, hello.
State your name.
Aurelius Terry.
What are we doing?
Hello.
Yeah, we can hear you, Mr. Terry. Please be muted. Your Honor, we
Sorry.
would be requesting adjournment to get the body worn cameras in this case. And Mr. Terry would like me to address bond if the court is willing.
Adjourn is June 1st, 2023. 9 a.m. Zoom invite indicates yes. Go ahead. It's just bound.
Your Honor, Mr. Terry was placed on a tether by the magistrate at arraignment. I believe that's due to his ties mainly being to Chicago. I don't really have any new information to present other than my office did receive an affidavit purporting to be from the alleged victim in this case, indicating that she does not want these charges pursued. But Mr. Terry was respectfully requesting the court consider removing the GPS tether.
Response from the people.
Your Honor, this is a situation where it's a home invasion first degree and a domestic violence as well as 2 counts of R&O. The tether was placed for the safety of the victim. I actually do not have any information about the victim saying that they do not want to proceed. And it does appear that he is a flight risk given the seriousness of the case and his criminal history. He has several ties to St. Charles, Illinois, Joliet, Illinois, and had cases in those areas as well.
Based upon all that information, and I don't have any information from the alleged victim in this case either. So motion for bond reduction or change of conditions is denied. Bond will continue as set.
This exchange reveals the hardest truth of bond hearings. Victim preference does not control prosecution. Even if the alleged victim says drop it, the state can proceed. Why? Because criminal law isn't private, it's public. Home invasion is not a dispute. It's a breach of collective safety. The state is the injured party, and the court sees 2 risks. A defendant with out-of-state ties, a violent charge category. That combination alone justifies restraint. But what seals it is history. Prior cases, geographic dispersion, pattern. This is why the judge doesn't negotiate. He doesn't compromise. He contains. Bond is not a reward. It's a filter. And Mr. Terry doesn't pass it.
Thank you.
Can I say something?
I would recommend against it, Mr. Terry. I don't think there's anything that we can say that would change the judge's mind on this one.
Can I say it at least? I just want to
say whatever you want.
Yeah, I just wanted to speak on the tether issue. I'm not a flight risk. I work here at Eisenhower Center, and they're telling me that I won't be able to work if I keep the bracelet on my leg. I'm not a flight risk. I don't understand why they even say that. I'm here. I have a good job. I'm not trying to lose that. And then like stay on the tether. The job is telling me that they'll have to let me go, which I'm not trying to have happen. I'm not.
Somebody's going to need to put that in writing. Give that to your counsel. I did not hear that. I have all of your ties being in the Chicago area.
Yes, I understand, but I moved here years ago.
Well, I don't. I have no idea about that.
I also wanted to speak about the affidavit paper that the defendant had sent over. I don't understand. I gave it to the public defender office. The state attorney office should have it also.
Well, first of all, that is going to be your attorney's decision about that, because there may be things contained that he may not turn over, but I'm sure with your law degree, you could probably tell him to do something different. So I'm going to continue my ruling if you are done. Bond will continue as it is.
This moment exposes the emotional fracture between law and life. From the defendant's perspective, this is catastrophic. A job at risk, stability collapsing, the feeling of being trapped by procedure. From the court's perspective, this is neutral. The judge does not evaluate impact. He evaluates risk, and risk does not yield to consequence. The tether remains because the alternative introduces uncertainty into a system that cannot tolerate it. That's the brutal truth. The court would rather disrupt a life than endanger the public. And that's not personal, it's structural.
Thank you.
When's the next court date? When's the next court date, sir?
First, as I said before.
Thank you. This is crazy. I don't understand. I'm going to lose my job for something that's going to be dismissed. Thank you.
He probably wants to mute himself.
It's not letting me mute myself. I'm sorry.
Yeah.
What this courtroom shows us is how pretrial justice really works. These defendants have not been convicted, but they have been assessed. Not for guilt, for trajectory, for stability, for predictability. Judge Simpson doesn't punish, he calculates. Every ruling you saw was anchored in one question. Can the court control what happens next? When the answer is no, freedom disappears. Not because the judge is harsh, but because the system cannot release into chaos. And that's the reality of bond law. It's not about what you did. It's about whether the court can trust what you'll do next. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.